resources for that purpose.
Good evening, everyone. Welcome to the third panel of the India Law Forum and LITFest 2022, organized under the aegis of the 82nd SKOCH Summit. Today, we're joined by a panel of eminent luminaries to discuss arbitration and Gati Shakti. In October 2021, Prime Minister Shri Narendra Modi launched Gati Shakti, the national master plan for multimodal connectivity. The digital platform brings together several ministries for cohesive planning and implementation of large-scale connectivity infrastructure projects. Efficient infrastructure building has been identified as a cornerstone for meeting national growth targets, and the first step is to address the historic problems of time and cost overruns in ongoing projects. So the panel today explores the many administrative, legal, and technological underpinnings contributing to the current challenges in infrastructural development. The average cost overrun for delayed projects has been found to be over 40%. So we're looking at issues like can technology interventions like BIM help alleviate such overruns and provide a data-based framework to arbitrators? And how can we ensure that arbitration awards are enforced in a timely manner? So it's my honor now to invite Mr. Sameer Kochar, reforms historian, author of Modinomics, and chairman of the SKOCH Group for his opening comments and for context setting.
Hi, thank you, Brinda. I actually have a brief presentation that will help us all, get our bearings on why we have chosen this particular topic as a part of India Law Forum this time. So, as you are aware that, it's a key project that Prime Minister Modi is talking about. But let's look at the scenario in which we are currently working. So this is the environment scan. The environment is not so good currently. The economy is not in the pink of health. If you look at state finances, they're also precarious. Unemployment rate is high, inflation is high, interest rates are going high, rupees going down, new investments are coming down, salaried jobs are coming down, consumer demand is coming down, and capacity utilization is not all that great. So this is overall India. And if you look at states, you have a similar kind of a problem. And this, obviously, all of this is quite, in the post-COVID world, is quite a challenge for India to get out of. So in the last budget, we find that infrastructure was seen as the savior. All the money that the government had, they wanted to put it in the infrastructure sector. So if you look at total expenditure versus capital expenditure, there's a huge growth. If you look at capital expenditure of key infrastructure ministries, again, there is a substantial moving up. If you look at budgetary allocation for key infrastructure schemes, again, scheme by scheme, there's a lot of money that is being pumped in. And similarly, infrastructure spending by state governments is also going up substantially. The idea is that this push on infrastructure may fix economy, employment, and GDP ahead of 2024 elections, because I think the key election issue in 2024 is going to be economy, inflation, and jobs. These are the schemes that are covered under PM Gatishatki to put a focus on all the projects, infrastructure projects. A scheme called Gatishatki was launched, so it takes care of about 81 projects out of the total projects that we have. But there are certain key infrastructure projects which are still not a part of Gatishatki, which we would like to persuade the government that they should also be put under that. So what Gatishatki currently is just a portal, where they're actually putting all the designs and project details so that the ministries are able to get their alignments right, to speed that up. But Gatishatki actually can do a lot more than that, because merely looking at a problem 3 times in a day is not going to fix it. So what this panel is going to discuss is that beyond a Gatishatki portal, what is it that we need to do? So we must differentiate between the Gatishatki portal and the Gatishatki projects. So some of the key factors that have been plaguing us is, time delays in major government infrastructure projects. Only 16.1% projects that are there are on time. 32% are delayed projects, and 51% of the projects actually don't even have a date of start. And this is resulting into a 18.18% increase in cost, which is huge. So if you look at the economic situation that I've already described, as it is, investments are low. So one of the things that India will have to keep a good eye for is incremental capital to output ratio. Unless and until every rupee spent is very efficiently spent and not going into time or cost overruns, we are going to miss the bus. So what are the reasons for time overrun? So there are issues with the state governments, which could be land acquisition, removal of encroachments, relief rehabilitation plans, etc. There are issues with union ministries, which could be environment, forest and wildlife clearances, tree cutting permission, grant of working permission, etc. And then there are causes for cost escalation, which are areas like underestimation of original cost, BOM is not correctly calculated, changes in the rate of foreign exchange, changes in statutory duty, high cost of environmental safeguard, so on and so forth. They're kind of shifting goalposts on this. So if you look at all these issues, they can actually be put into 3 buckets. One is, administrative bucket, which is, so what is it that you need to do as an administrative reform, or, pushing the administrative envelope to make sure that things are happening in time. Second is the judicial bucket, where, clearances, etc. are required, or arbitration is required, and arbitration awards have to be implemented. As we've seen in the past, the entire system the banking system was coming to a collapse because the infrastructure projects had so much capital blocked. The vendors were not getting paid in terms of lakhs of crores. And if that money is not in circulation, then how do you work on infrastructure? So how do you make sure that more and more arbitration is done rather than going for litigation? And more importantly, how do you speed it up, and how do you ensure that the arbitration awards are actually implemented? The third bucket, which is the most important bucket. Now, the first 2 will take a lot of doing to do. I mean, it's easier said than done. And obviously, we have to make an effort that this administrative reform happens. The wheels of arbitration are well-oiled, happens faster. But one of the areas where we find is that we are still almost like in the early 20th century in terms of technology. We are still doing paper-based drawings. We are hardly doing 2D, whereas the whole world has moved to highly technology-oriented project management. And that is an area where possibly, a lot can be done, and it can be done faster. If you look at what the rest of the world is doing, and this technology actually helps even in arbitration, because, most of the thing is on cost escalations, bill of material, time delays, etc. So if you have something called BIM, which is Building Information Model, it can sort of help you figure out all that. So you can actually have a knowledge-based argument, and you can practically have a real-time view of where the bottlenecks are. So it is a set of information that is structured in such a way that data can be shared. A BIM is a digital model of a building in which information about a project is stored. It can be 3D or 4D, which is integrating over time, or even 5D, including cost, right up to NDs. So if you look at the Gatishatki portal, they're even going up to putting geospatial data on top of it. But right now, as I said, the Gatishatki portal is not BIM enabled. It is just a data dump. So then that data will become meaningful only if there is a underlying BIM system around that. So if you look at the challenges in India, the first challenge is lack of code. These are challenges that are actually identified in the government of India itself, which is why they set up Gatishatki. The first one is lack of coordination. So if you look at globally, there are several projects who have used BIM to solve this lack of coordination problem. Second is wastage of time. This has also been several global best practices are available on that. Lack of holistic planning, cost overrun, and duplication of work. So there are global best practice examples available in each one of these areas that kind of have where BIM has been used to handle this. If you look at in USA, the General Services Administration Department, which looks after all the building projects, public building service projects, has gone in for 3D, 4D building programs since 2003. Even the US Army is doing it. Similarly, there are examples in UK where as a policy direction, they've done it. In Denmark, they have done it. If you look at where it has been done, in USA, their contractors are reporting 25% improvement in labor productivity, 25% reduction in labor costs, 5% reduction in final construction costs, and 5% increase in speed to complete. Similarly, there are advantages, documented advantages, which are available as papers that are there in countries like UK and in Singapore. In fact, in Singapore, they say adoption of BIM has accelerated the construction activity by up to 30%. So then it makes a very compelling case for India to look at something like that. BIM, of course, as I said, it's a lower hanging fruit. Our problems are much larger than that. Administrative reforms and the judicial reforms being the two key. And also the structuring of the contracts, because our tendering system is terrible in the sense that people bid below cost, and then because they bid below cost, time and cost delays and all this are used effectively to make good, and you actually end up paying much more than what you had planned to do. As I said, that we were looking at 18.18% cost overrun already in most of these large projects, which is also going from the taxpayers' pocket. So with that, I leave the floor open to Pranay, Lekhi, who's been helping us put together this session. And Pranay, if you could help us bring this together and get this discussion going. And before we do that, I think Brinda has to introduce the panel. So Brinda, if you'd kindly do that.
That's right, yes. Thank you, sir, for raising some very important issues and helping set the stage for conversations to come. My pleasure now to introduce the panel. First, we have Dr.M. Ramachandran, Distinguished Fellow, SKOCH Foundation, and former Secretary, Government of India. So he's referred to as the infrastructure man in Uttar, where he was the chief secretary for undertaking several important public-private partnership projects, including the lining up of a $1 billion assistance by the Asian Development Bank for the power, road, and urban sectors, as well as $120 million in assistance from the World Bank for the drinking water sector. Dr. Ramachandran has played a pivotal role in the implementation of the Jawaharlal Nehru Urban Renewal Mission. Then we have Mr. Sunil M.K., who's the country manager for architecture, engineering, and construction at Autodesk India. He's an industry veteran with over 20 years of experience in the software industry. He's been involved in evangelizing BIM across Asia-Pacific markets since 2011 and has worked with various large private organizations and government agencies driving BIM mandates. We're also joined by Mr. Sunil Mokin, Counsel for Allen & Overy in UK. He specializes in high-value and complex construction and infrastructure disputes. Since 2020, he's been recognized as a rising star in international commercial arbitration by Legal 500. He sits on the steering committee of the Young Practitioners Group for the Mumbai International Arbitration Center. We have Mr. Jatin R. Jalandrawala, Joint President Legal, Adani Enterprises. He's worked with various regulatory authorities like the Ministry of Corporate Affairs, Stock Exchanges, RBI, and others on matters like corporate laws, litigation, arbitration, contracts and agreements, corporate governance, and compliance, to name a few. We have Mr. Sapan Gupta, who is the Group General Counsel for ArcelorMittal, practicing in both New York State and India. Mr. Gupta has worked across sectors like steel, mining, power, ports, banks, real estate, and non-bank finance companies in a lot of legal niches, including but not limited to mergers and acquisitions, dispute resolution, banking and finance, bankruptcy, industrials, and infrastructure. And finally, we have our moderator, Mr. Pranay Lekhi, who's a legal advisor on international arbitration at Allen and Overy, UK. Mr. Lekhi is one of the youngest members of the drafting committee of the Law Commission of India and a part of the expert subcommittee analyzing India's 2015 draft model bilateral investment treaty. He has published research in key areas of international law and international commercial arbitration. I'll hand it over to Mr. Lekhi now.
Thank you very much, Brinda. And thank you to Samir sir for setting the context of this discussion so well. Construction in India is the second largest industry, second largest employer, and the second largest recipient of foreign direct investment. It is no doubt that there's a reason why there's a renewed focus on this sector as India moves ahead with its growth story. But as Sir rightly pointed out, that there are issues of cost overruns and delays that can be summarized in one trite word that's emblematic of the construction sector globally, and that word is disputes. So how India proceeds to manage its infrastructure and construction disputes becomes a key factor on seeing whether this growth story becomes a success. So this discussion will essentially be phrased in three sectors. First, we will try to understand each stakeholder's view on the current issues that plague the Indian construction and infrastructure sector. Then we will see how contractual arrangements and technology can assist in planning and implementation. And finally, we'll have a discussion about the efficient management of disputes once they arise. So I will now put the first question to this very illustrious panel, and I will go to Dr. Ramachandran. Sir, as Mr. Kocher pointed out, that beyond the issues of efficient management, there are certain administrative and judicial laxities that the Indian construction sector faces. To set the foundation of this discussion, please could you briefly tell us the issues that the government infrastructure projects have faced in the past and what led to the creation of an idea such as Gatishatki?
Thank you for that question. I'm also a little bit concerned about the link between arbitration and Gatishatki. I see Gatishatki as a very forward-looking step and based on learnings from the past. Years back, we used to talk about time and cost overrun on a continuous basis. They are still there, but in the present scheme of things, monitoring of infrastructure projects has taken an entirely different turn. But rightly, I think the Prime Minister realized that is not enough. So 21 ministries coming together and having a common platform is a big step as far as infrastructure projects in India are concerned. And I do hope with this portal coming into existence where ministries can log on to this portal and take up projects or bring about the integrated approach which is required, that should be possible. The Gatishatki write-up itself talks about some industrial estates started years back. It couldn't move forward because there was no coordination with other departments. The classic example is that of a gas pipeline laid in the state of Kerala, which took 8 years for the gas to reach whoever the ultimate consumer is supposed to be. Years back, I mean, during my days, I remember the Planning Commission talking about we have a silo-based approach, meaning each ministry has its own domain, and if a road transport project is taken up, if it has to be linked with say, ports or so, unless other ministry also comes in and there is a joint effort and there is a decision by the cabinet, it won't really move forward. I think that barrier will be broken as a result of this, and now there is freedom for ministries to come in. Now, one or two fundamental questions to me, points to be borne in mind up. I think here we are talking about only about public projects. We are not talking about private projects. And that's a story by itself. Nothing much is written about that. Nothing much comes to light. And Samir also focused on the public projects. So now that I have an opportunity to be associated with private projects also, I can see such delays and problems as far as private projects are also concerned. So one of the points I checked with the Secretary, Department of Industrial Promotion is whether private projects also can come onto this portal. I think that's the ultimate idea, though currently public projects will come. subsequently private projects also can come in. Now, again, I can give a classic example. There is a new airport coming up. The connectivity to the airport is something which has to be provided by the Highways Authority. How does the coordination come about? We know of instances like the Hyderabad airport and even the Bangalore airport, where the airports became functional, world-class airports became functional, but the connectivity was not there. So the players involved in our Indian scheme of things are too many. It's not only the central ministries which work in silos, the state governments also come in, and state governments come in actively if they have an interest in the subject. So it's a question of center and the state working together. To that extent, I think if this is a good beginning, probably this should lead to results. To what extent time and cost overrun will come down, probably it's difficult to predict, but hopefully it should come down, and a better form of reaching the target should come about as a result of this. Thank you.
Thank you very much, sir. I think I'll now move on to Mr. Jalundwala. So as Mr. Ramachandran pointed out, that the creation of the Gatishatki portal will probably be a step in the right direction to create better coordination between the ministries. But in your experience of engaging with large-scale infrastructure projects, both with governments and private parties, what do you believe are the fundamental limitations that your engagements have brought forth in the context of disputes?
Yeah, good evening to all. So you all know, okay, India is expected to become the world's third largest construction market by 2025 and will require investment of INR 50 trillion. For this purpose, the infrastructure facilities like road, railways, metro rails, and so on are required. And they are nothing but the backbone of the economy. If the infrastructure is well organized, the economy will go at a faster rate. But there are certain limitations as far as these infrastructure projects are concerned. And let me put before you, first is the project cost in India. The cost of the project is mostly calculated by the private party and the lenders who will fund it via stock and debt. The risk, which is key risk connected with cost and schedule overruns, are the major hazards impacting project cost in India. Delays in acquiring forest and environment clearances, delays in land acquisition, and lack of infrastructure assistance are the primary reasons of schedule overruns. Second limitation is land acquisition. Say delay in handover of the land. Acquisition related disputes are one of the major issues faced by private parties, which has always a cascading effect on the project implementation and completion. If I give one example to you, that is the metro rail project as far as Ahmedabad, where I am here, is concerned, which was likely to be over in 2022, is yet to be completed, which may take another 2 years because there were so many disputes and other things about the land, other things were going on. Similarly, clearance from numerous agencies in India, most of the infrastructure projects suffer from delays in completion. This is mainly due to the inadequate regulatory framework and inefficiency in the approval process. Infrastructure projects require multiple sequential approvals, clearances at various stages, and delay in clearances holds back the financial closure of the project. Similarly, environment impact assessment, environment safeguards and guidelines have proven to be one of the major reasons for delay in infrastructure projects. You all know, okay, suppose I get the infrastructure approval, that is environment impact approval. Even anybody can challenge in India within 60 days to National Green Tribunal. And in such disputes are going a long way for the project to be implemented. All the shortage of labor, another important point, that both skilled and unskilled laborers are not available much in India. There is always a shortage, and this has a dual determinant effect on the sector. First, it hampers the delivery of the project, both in terms of the time and quality. And secondly, it also drives up the cost of the project, reducing the profitability. All these are the main limitations of the infrastructure project in India. No doubt, a lot of things have been done by this government, but a lot to go ahead as far as the limitations are concerned. Over to Pranay. Thank you.
Absolutely, sir. I think that's a brilliant point. Just to take that discussion a bit forward, Mr. Sunil, Mr. Jalunwala has very appropriately highlighted what the issues that make the construction sector anemic in India are generally and over the years. And now, despite there being a renewed focus of the government in creating large-scale infrastructure projects, we are witnessing the sector be under stress in the current scenario. Till the middle of last year, there was about $18 billion worth of loans in the real estate sector that were under stress. Do you believe that there are any specific issues that the sector is currently facing that also need to be addressed?
Let me just talk about the issues that is actually been addressed by Samir as well as Jatin and Mr. Ramachandran. Rightfully, all the issues that we just heard, I think the key thing is that it is happening because there's no transparency and accountability that's actually in the entire segment itself. When you talk about getting everybody together in the Gatishatki portal itself, one thing would be also to think about how contracts are put together. You know, what kind of technologies are there that actually bring about transparency of data and the projects itself in terms of how it is being, the construction is going on, and looking at all the issues in terms of cost and cost overruns or time delays and stuff like that. The other part is, even if we provide technology, just as Mr. Jatin said, that we have a challenge around people, right? The skilled labor that's out there. Who is going to use this technology? So it is important that we actually have a process where we enable the system also to be trained to use this technology, whether it is hardware, software, right? So one piece is the software, then robotics itself in terms of hardware plays an important role in actually delivering the projects more efficiently, right? So I think that could be one of the reasons where the stress levels are seen. But from a software segment where I come from, when I'm actually selling into the industry, I find large construction companies and large owners have actually started using technology that actually drives some bit of transparency and accountability. But largely still small and medium to medium players still don't have much of technology in the construction space. That being said, will BIM alone or some technology like BIM alone help in actually driving this is a question. Actually, I think BIM is a database that actually will help us to drive some of the decision that we need to make. But also what we need is actually an idea where you actually share the design as well as, you actually create and share the design data effectively. So I think a collaborative platform is something that is important in today's world, where everybody needs to be on the same page. And most of the project that I see is run without a collaborative platform, right? And we are involved in many of the projects. And that itself, actually, one of the inherent problem in the industry has been cost delays and budget overruns. is just because of miscommunication and collaborative challenges that we have. People don't have the right information when they need it, right? So we need to fix all of these challenges, and that will help drive some of this challenge that you just mentioned.
Thank you very much, sir. Mr. Gupta, a related issue that comes up in the construction sector, and one that is the most emblematic of the disputes, is the issue of enforcement of infrastructure and construction contracts. More recently, in relation to the enforcement of arbitration awards, the government has framed rules for the release of 75% of the award money to the award debtor contractor in case of government contracts. So clearly there's a focus on moving in terms of a direction where challenges to enforcement are limited. But given your broad multi-jurisdictional experience, what are the current limitations that India faces for the efficient identification of the root causes as well as efficient resolution of the enforcement issue?
Thanks, Pranay, and thanks to all the speakers. I was reflecting on what Mr. Ramachandran said at the beginning, that the connection between Gati Shakti and arbitration. So I was just thinking that the whole power of speed can be stopped by the lawyers and judges, which we are known for. So unless they are not on board completely, it's not going to move, unfortunately. So the processes needs to be, the legal processes itself needs to be tightened up, and government in India has been the highest and the biggest litigator for a very long time. So we really see a big connection that if the infrastructure in India has to move, or for that matter, any industry has to move faster, then the law making and the law enforcement has to be in sync. Otherwise, the courts can really delay and kill the scheme. Now, coming back to what Pranay has asked me, look, but what is happening, especially in India, is that most of the contracts have arbitration. They have very limited interaction of the courts, except for enforcement procedurally. Like whether 34 has been filed or 47 has been filed after arbitral award has come. But the courts are really not laying down the jurisprudence. The jurisprudence is being laid down by the arbitrator. Now, the disadvantage with that is, one, it seems from outside that the arbitration is faster, but it is not. That now you say 18 months, but the decisions are not being taken in 18 months. And secondly, the application of law probably in the first instance, when some of these laws are very new, should probably happen at court level, and these are not public. The arbitration arguments are not public. Arbitration awards are not public. So there is no proper scrutiny, and I'm speaking only from the legal analysis, is not really happening. Yeah. And arbitration is a growing field, but it still doesn't attract the best of the people in the profession. And when the arguments happen, a lot of reliance is being placed on English law and external precedences, and not on Indian law, because there are not enough precedences. So the basic fundamental change is that if arbitration is happening, should it be made a little more public, or should courts have a little more say on where it is going? On the other parts, what we feel is the liquidated damages. If we look at in other jurisdiction outside India, the clauses are good enough. If there is a breach, you make a demand, you get your liquidated damages, and the case goes on. In India, you have to prove that the damages happen. So contract is followed by proving it has been laid in ONGC versus SOPA, it has been laid in Kailashnath versus DDA. And that creates a lot of work. You have to submit evidence, you have to get experts, and it takes a fair amount of time where you get to the payment. And the overall thinking in Indian legal profession, including lawyers and judges, the liquidity damages are not avoided. We are not a jurisdiction which like liquidity damages per se, with or without infrastructure. So that is something which remains quite unenforceable in India. The other provision which we see as a problem is bank guarantee, and we play both roles. We play the role of employer, and we also play the role of contractor. And bank guarantees in India is like a bearer note. Unless there is a fraud or there is an irreparable thing, you just can't stop it. And when you sign contracts with government, you have very limited say in changing those drafts. Those are very black and white draft. So you are on the hook. If something goes wrong, you just bank the guarantee and then you're stuck, you're out of money. So should there be a concept of conditional bank guarantees that, okay, when this is met only in certain circumstances, the BGs can be invoked. And for the MSME, for the large organizations, it's easier because you have a cash flow coming from various sides and you are able to manage. It's difficult, but it's still manageable. The smaller the enterprise, the difficulty is that if one or two bank guarantees are in cash, your ability to participate in future projects, your ability to raise more money goes down considerably, and it could hit you in a very material way. So we basically see these as major issues. One of the other issues which is very, very limited in Indian context is insurance. Like we had a situation in Ukraine for a different reason, but you have insurances. We see it in Canada. We are fighting a very, very large case. But the insurance money is always available. The contracts are supported by insurance. In India, it's really, really hard to get those insurances. Insurances are very expensive if at all they are available. The amounts are very small. So that's one more thing which probably needs little more work, that in infrastructure contracts, the insurances on liquidity damages, insurances on performances are introduced. And I think that's broadly, I would say, from the purely legal perspective.
Thank you very much, sir. That was exceptionally helpful in grounding this discussion. Just to understand what has been discussed in terms of limitations in the context of disputes globally, Mr. Morkin, you have witnessed and heard our panelists speak about the limitations that the Indian construction sector faces. Could you tell us from your experience, are they common to those that large-scale infrastructure projects face generally? And could you give us a flavor of what are the sorts of common disputes that arise in such projects as they go along?
Of course, and thank you very much, Pranay, and to SKOCH for inviting me on the panel. I mean, many of my colleagues on the panel already have discussed the issues that arise on these types of projects, some of which are very unique to India, such as kind of land acquisition issues, regulatory approvals, or I should say more common to India. But the nature of construction projects, the length of time, the amount of money at stake inevitably means that disputes will arise, and they are very common. I wanted to reflect on perhaps four issues that I see very often that lead to disputes on construction projects, and talk about them in a bit of detail. The first is lack of design maturity. The number of projects that we see that go to disputes due to failures at the very outset of the project in the design phase. And my colleagues touched on this earlier in this panel when they're talking about the use of BIM and the fact that India has not developed the same advances in technology to help with the designing of contracts. And I think that is a real key element here, because getting the design right from the very outset is fundamental to the long-term success of construction projects. Design growth or design change, to some extent is inevitable, but significant design growth through the course of a project causes significant disruption and results in significant claims by the contractor that inevitably ends up in formal disputes. They put considerable strain on the schedule, and it means that if you're starting with an immature design, you haven't got a fully developed 3D model, you are very much starting the project from the back foot, from the very outset. The second issue that I think comes up, or it's relevant to this discussion, is failures in the actual tender process. Selecting the correct contractor, I mean, taking from the view of the employer, and then from the contractor's perspective, getting the right subcontractors to do, your other scope of work is vital to the contractual, to the success of the contract. And I think, in a market where the provision of services is very competitive, as my colleagues have touched on, price becomes a very determinative factor. There is a race to the bottom in terms of cost, sometimes because, well, inevitably because contractors know that during the course of the project, they can bring a whole host of claims and try and get more money. And all too often, there's too much emphasis in the tender process on people going for the low cost option, rather than looking at demonstration of proven track records and experience in executing this type of work, and getting credentials where they have completed similar projects on time, in budget, so that you have safeguards in place. So more integration during the tender phase, in ensuring contractors' experience and expertise, I think, is vital, coupled with implementation of contractual safeguards to then ensure that when you've got your contractor in place, you do in fact get their A team, rather than the C team that they're then given to your work. So making sure that what they've told you on paper during the tender process is actually what they deliver during the course of the project. The third big issue, I think, is just sheer contractual uncertainty. The number of disputes that arise due to ambiguities and uncertainties in the drafting of contracts that can lead to mega claims between the parties is incredibly prevalent in this area. And I think one area where India can perhaps move forward is to try and use more of the kind of industry standard form contracts to the extent possible, things like FIDIC, JCT, NEC, etc., where there has been better safeguards in place to ensure that the contract hands together, and obviously provides better protection in respect of claims. I think another note on there is what we see very often in projects is recycling of old contracts. You have a contract that's been used for a different project, sometimes of a completely different nature, and someone gets it off the shelf and recycles it for a project which is very different, and that ultimately leads to tensions, can lead to a significant amount of inconsistencies between the contract or uncertainties that inevitably leads to claims. And then the final area I think is perhaps the most significant here is simple failures in project management, and that's obviously a very broad topic, but too often than not, after the contract has been signed, insufficient attention is then given to the actual management of the project. And as I've said, and we've discussed in this panel already, it's inevitable that disputes will arise, or issues will arise rather, but how they are managed by both contractor and employer teams during the life of the project can be the difference between project success and failure, and be effective. And if you do it properly, be a very effective means at managing disputes. So one very common issue we see is in respect of scheduling. Having a fully logic-linked project schedule from the very outset of your project is vital to ensure that your project keeps on schedule, and that if there are any slippages or delays, they can be mitigated. You have it's very common in the construction industry to have kind of Primavera, which is construction software, different levels of schedule, which gives you different levels of detail, and ensuring your contractor or working with your employer keeps that regularly updated with 2 weekly, 4 weekly look ahead priorities, means that when something happens, be it an intervention, a delay in a government approval, issues with land, you know exactly where you are, and you can think, okay, well, what can I do instead to mitigate that delay? What are my other required work fronts that I can now progress instead to mitigate this delay? And too often than not, the schedule is a simple afterthought. And I think by the time people realise where they are in terms of the schedule, it's too late to mitigate the extent of any delay. Relatedly, ineffective, insufficient claim management. So again, you will get claims during the life of the project, but often they come in, they're not properly analysed at the time by employers and responded to, or they're responded to in perhaps a superficial way, which fails to engage on the actual issues at hand. It's a way of just parking them until the end of the project. And that creates a backlog of claims at the end that then results in a mega dispute, and also helps or rather creates poor relationship between the parties, between the employer and the contractor. Parties become entrenched very early on in the contract phase during the execution because you're a million miles apart in terms of these claims. So being very clear from the outset with contractors and with employers about the processes that must be followed in respect of claims, requirement to comply with notice provisions, what information must be provided in support of your claims, setting that from the very outset of the process, in my experience, makes things much smoother and fosters better relationships. And this is a role we've been increasingly playing with our clients over the last years, is getting involved before disputes arise, get support from your legal team. All of the big employers, contractors, everyone has internal legal departments. Get involved in your contracts earlier on before the disputes arise to make sure that you're getting the required deliverables from your contractors, that employers are making use of any contractual bars in terms of entitlements, such as notice provisions that haven't been complied with, so that you get a much better start at the commencement of disputes, or even can prevent disputes occurring altogether.
Thank you very much, Mr. Morkin. That was exceptionally helpful. And that actually makes it easier for us to lead into the second half of the discussion in relation to finding better solutions to the current issues that the Indian dispute sector faces in relation to construction disputes. I think specifically to pick up on a point that Mr. Gupta mentioned on the clauses of liquidated damages not being drafted well in Indian construction contracts. Mr. Gupta, we've heard Mr. Morkin speak about the increased use of standard form contracts such as those of FIDIC and JCT as a mechanism to solve the issue of bad contractual drafting in the Indian construction sector. But this sector is also marred with government entities such as the National Highway Authority of India, which has its own standard form of contract and a separate legislation which the Supreme Court has held to have a preferential right over the Arbitration and Conciliation Act. What, in your opinion, are the key issues that infrastructure contracts in India should address but fail to do in status quo? And as an additional point, do you also think that there's a requirement of a specialized practice of construction disputes in India, for instance, having, a construction and technology court similar to what is there in the UK?
Thanks, Pranay. I think building up on what Sunil said, I think one of the most important point is record keeping. And it also goes back to the point what MK Sunil was making on technology. The project management is pretty bad, and it's not only India, it's most of the developing countries. And the use of technology is minimal. And when you go and file your contracts, there is not enough documentation which really could convince or pass the legal test, which now is fairly easy with the technology being available at each stage where you are, with photographs, technical analysis, a number of things are available, which is not really done. And hence the provision which exists in most of the contract is that the contemporary record needs to be maintained, needs to be implemented and followed. If there's a litigation, then there is a sort of a huddle, and everyone is looking for a document, and then you put together on the basis of what you have, but you don't do it from day one, which really creates a bit of a problem. A couple of other things which we see is in specifically in India is this. One is the unilateral appointment of arbitrator. Of course, you have a 2019 judgment in Perkins Eastman that clause is not valid, but it still exists in a number of contract, and the employer enforces that, especially government. So the contract needs to be amended to really say that it has to be a 3-party arbitration. But that's wasting a lot of time in appointment of arbitrators in the court. And then the multi-tier arbitration. Amicable solution. If that doesn't work, then you go to some sort of an inquiry. If that doesn't work, then you go into arbitration. And if that doesn't work or there's a dispute, then you go to courts. Yeah. And the accountability system in India, in most of the developing countries, is like that once there is no amicable solution or once the clause is invoked in the agreement, then more or less you can assume that it will end up in courts, because the accountability increases so much that no one wants to take the decision. And then just it's a sliding path, or a sliding slope. So these are the main contract issue which we see, and on a larger level. And coming back to your specific query on whether there should be specific tribunals, there should be specific contract, it again goes back to a very a specific point one of the panelists made, that we are talking about public contracts, we are not talking about private contracts. Now, L&T, which is a private company, is the largest infrastructure company in the country, which has the most contract, and that is true for a number of other players. So you need investments in these courts, you need experts, and you need a practice where people can come in and invest their time. So whether the industry is ready or not, it's not very clear currently. And a lot of private contractors, especially when one party is overseas, which is very true in a number of infrastructure contracts, leave aside roads and all, but in highly specialized industry like ours, most of the time the counterparty is international, and they don't accept Indian jurisdiction. They want to do it in Singapore or London. So one is that how many contracts can you really try in India of this nature? And second, is there enough focus that the tribunals can be created? Because at the end of the day, these are commercial contracts, and generally the litigation in India around procurements and contract is relatively low, especially in the private parties. It's a self-serving system. People try to reach an amicable solution unless it really goes out of the way. So I think it's very hard to say that is the Indian market ready for a specialist practice on construction. And then that is very visible. If you go to a firm like A&O and a number of other firms, there are specialized practices on construction. There are lawyers who only do construction cases. In India, there is nothing like that except few lawyers who do NHAI work in Delhi. So from that perspective, I think it is too early to jump to that proper infrastructure. I think the current structure needs to be strengthened before we move forward.
Thank you very much, sir. That was exceptionally illuminating. Mr. Sunil, Mr. Gupta mentioned the point of investment in experts as a precondition to such infrastructure being developed. The sector involves, among other things, the assessment of delays, which involves the identification of critical paths of completion and studying deviations, aspects which are highly technical in nature and would require expert analysis, which doesn't seem to be happening in the sector right now. In your opinion, how can technology assist dispute resolution forums for such issues to be resolved more efficiently and correctly?
Right. So BIM is definitely, as many have spoken, the foundation of data creation, right? So for all the projects. So it's basically, unlike the CAD, which is line, arc, and circle, in BIM, we generally use real world components like wall, door, window, columns, beams, structures, and all of that. And you actually create a virtual design model before you go into construction. So possibly having a data which has got all the information, where you can actually look at all the flaws and you can fix it before you go into construction. So the first thing is having, Mr. Maukin also said, having the right design in place, right? So BIM allows you to do that, where you actually fix issues and challenges, all the issues before you go into construction. That's one, right? Of course, changes, as he said, changes can keep happening, but then it is also visible, and it's much more easier to make those changes and validate and make sure you go ahead with that knowledge. The other piece is actually sharing this data, as I said earlier, through a common data platform where all the information can be captured right from day one, right? So how many times do we have a knowledge of a contract document changes that happened over time, right? So having a common data platform allows you to do that, that all the changes you could actually go back anytime, even after 10 years, 20 years, and look at why those changes happened. All the communication, all the discussion that happened. So if I was a approving person of a design, if I do a red mark, redlining, and put my comment, it is captured in cloud. And that information stays there. So if there is a litigation after 10 years, 15 years, you can quickly go back and look at this information that is on the cloud and actually take out what is needed. Today, actually, when I talk to my customers, the biggest strategy people have in terms of sharing data is email, right? An employee leaves and that email is not accessible. Some people have FTP portals and all of that, but those are not designed for construction. So there are common data platforms designed for construction. Even we have from Autodesk, other competition have it. So if you use one of the common data platform, you have ability to understand, one, version control is built in. You know, you don't share old data. You only look at the current data. That itself is a big step forward, because a lot of rework can be is actually associated that, oh, I didn't have that data, I did not get that email, or I did not, I missed that information. So the first level is that. Then of course the second is all the communication is captured on cloud. That gives you ability to go and understand what and how people made those changes, who took decisions and all of that, which will help you in litigation and arbitration. So having the information on cloud definitely helps you. Quickly finding this information on cloud is so much easier, right? Going through a bunch of papers and drawings is definitely not something that people would love to do. So technology can definitely help. One is, of course, a process of design, which is BIM, which captures all the information. And the second is basically how you share that information effectively and keeping that whole information so that you can access it anytime.
Understood, sir. Dr. Ramachandran, I think what is clear from this discussion is that construction disputes are definitely very dynamic and very unique when compared to other forms of dispute. I think, to quote a 1974 Arkansas federal judgment, a judge said that construction disputes are a separate breed of animal. But we see in India, construction disputes are primarily dealt with under the Indian Contract Act and Specific Relief Act now. But recognizing these distinct issues that construction disputes face, do you think there is a need to have a separate legislation that governs construction disputes, similar to what you find in jurisdictions like the United Kingdom, Singapore, and Malaysia, for instance?
Well, I may not be the right person to comment on that because I'm not a construction specialist. But having listened to all these points which have been made here, I think your effort is to come down to the construction sector and the issues related to that. very broadly, what I would say is what comes in the way of proper development of infrastructure projects is, of course, one factor is the contract management, how the contract is drafted and how the contract is managed. I was reminded of an instance where in the Delhi Metro, the then MD decided that if a contractor has a specific problem in mobilizing resources, an advance will be provided to the contractor, and so that he can take the project forward. That was one way of looking at things. I'm glad the auditor did not make an issue out of that, because such a facilitation is not provided normally in the scheme of things. Whenever we are prepared to go out of the way, facilitate, that's one thing. Then all this leading to disputes. I see quite a number of disputes coming up, and I think the arbitration process becomes quite long. So in the context of the PPPs, there was a discussion at one stage whether we can have a dispute resolution mechanism outside the two parties. And whether that will help facilitate sort out issues a little better rather than go through the long drawn-out process of whatever is legally provided for. Now, whether there should be a separate legislation for this, it's something for experts to comment. But I think in the larger scheme of things, what needs to be looked into is how contracts are structured, how they are managed, and what further can be done. I'm not very sure much can happen in this, because for each contractor, I think this would be a field close to him or her. So how much of it will get shared, I'm not very sure whether it is possible to have it, and it can be an open data as far as the entire process is concerned. And I don't think that has really been happening because of the competition issues, because you have to bid and get a contract. So I suppose that's the starting point where the competitive participation starts, and probably it gets built over a period of time. So it's a question of evolving on the basis of experience, what more can be done. And if the legislation is one way of doing it, I see more disputes coming up, more matters ending up with tribunals and courts and things like that. Project gets held up again, unless there is a solution that the project should go on and the dispute can be resolved separately. I don't think that type of a scenario will come about. So I don't have a direct answer to this. It's for those who are involved in construction procedures. Just to link it with the real estate part of it, we know any number of instances where there are delays happening. It's not essentially the contract, but it is related to raising resources and taking the project forward. There have been delays, and many people who were hoping for a house had to wait for years and years and years. So there are situations like that also. Once RERA has come into effect, I hope there is some solution, but there are a large number of cases outside RERA which are not getting resolved, and there are people who have paid money and they are not getting their money back, nor are they getting a house back. So that's a complex issue as far as construction. Again, I think we have to make a distinction between the public sector and the private sector, and we have to have clear approaches. Thank you.
Thank you very much, sir. And just in the interest of time, if we proceed towards the efficient management of disputes, I'll ask my first question of this part to Mr. Jalunwala. Sir, in your experience, could you tell us whether arbitrating disputes in India is an efficient alternative that you find to litigation in the context of large-scale infrastructure projects with government entities? Or do you think that arbitration in its current form is a genuine alternative to litigation in civil courts?
Yeah, thank you, Mr. Pranay. Say this alternative dispute resolution, the arbitration. In fact, as far as infrastructure project is concerned, the arbitration, even if I say the ad hoc arbitrations versus institutional arbitration, and I prefer institutional arbitration to be more precise, more time bound, and more systematic. However, what happens even the arbitration award is declared, as per the infrastructure project circular of the government, 75% of the amount is to be given to the party who won the award, but subject to the release, subject to the submission of the bank guarantee. It has become difficult. Even we are facing as infrastructure companies. Then we go for the bank guarantee. In a disputed such thing, the banks are asking 100% margin. So what is the use of getting this money? Secondly, what happens in number of arbitrations I am facing, suppose I receive the award in my favor, the other side is going to section 34, then 37, and thereafter to Supreme Court, which takes a longer time and maybe for 2 years, 3 years down the line. It's essential in India to have the commercial courts to function more effectively and more efficiently with a time-bound manner that section 34 and thereafter 37 has been disposed of at the earliest. Because the end goal and focus of the dispute settlement mechanism should always be on ensuring maximum time and cost saving, which being effective. The Indian construction industry is highly prone to litigation and disputes arising out of the loopholes in contracts. And legal industry is no stranger to stretch out legal battles and multiple claims on wrongdoing by subcontractors. Construction disputes are inevitable. It includes range of activities involving complex infrastructure projects, engineering works, commercial and residential construction, built-up works, development projects, among others. The Indian construction disputes environment is still a work in progress and long way to evolve into a mature jurisdiction and face several cultural issues. Arbitration has been evolved definitely as a good system, and after the 2015 amendment, most of the arbitrations are likely to be over in 12 months, but 12 months not, but additional 6 months or so. And therefore, it is very important that the arbitration process is over in a time-bound manner. Parties prefer arbitration due to the freedom and flexibility to choose the tribunal, given the requirement of specialized and technical knowledge in this sector. No doubt, you know all that English in India, in UK, where we have English technology and construction court, but India has also sought to establish special courts, but it has long way to go for working of these special courts, say I'm saying commercial courts, more effectively and more efficiently. There is a need for effective case management techniques. Lack thereof creates an issue. And therefore, till we have such specialized courts in place with professionals having technical expertise and above all practically implemented, litigations won't be actually preferred. Say COVID-19, you all know, has been considered as a force majeure event in construction disputes. Reliefs awarded for road construction contracts, including extension of time, certain direct payments to subcontractors, and relief from liquidated damages. Recently, the amendment in the Specific Relief Act, that is 1963, prohibits Indian courts from granting injunctive relief in civil proceedings for specific performance of the infrastructure projects, where that injunctive relief would impede or delay the progress or completion of the project. And that is the very, very attractive step taken by amending this Specific Relief Act. Another trend that has been witnessed is having multi-tier dispute resolution clauses. The requirement to go through the DRB have been held to be mandatory. It is settled law that when the parties agree for a specific procedure and mode for settlement of the dispute by way of an arbitration and prescribes certain preconditions to be complied with for referring the matter to arbitration, the parties are required to comply with those preconditions and only then refer the matter to the arbitration. So in a way, this arbitration, that is alternative dispute resolution, is an effective step to close the dispute at the earliest, but it has to be monitored more properly as far as the time is concerned and cost effectiveness is concerned. That is what I have to say here. There are a lot of examples which I am having, but it is a time constraint I cannot give, because if you see the one particular arbitration award, we won before 3 years down the line, but till date we have not been in a position to get the fruits out of the award.
Right.
So this is happening across.
No, absolutely, sir. And I completely share your concerns about the enforcement issues with India as a jurisdiction of arbitration awards. And I think as we move towards the conclusion of this discussion, that is sort of a good segue into understanding the issue of finality of arbitration awards in India. Mr. Gupta, Mr. Jalunwala has highlighted a number of both positive and negative developments in relation to the enforcement of arbitration awards in India. On one hand, we have the Specific Relief Act amendment that's come in, and on the other hand, we have the issue of award debtors and contractors having to pay bank guarantees in order to get their money out of the state employer. How does India avoid this issue of enforcing an arbitration award, and what are the sort of best practices that can be used to make India a dispute-friendly jurisdiction in the context of large-scale infrastructure projects with the government, which is a sine qua non of having successful infrastructure projects in the program of Gati Shakti, for instance?
I cannot echo more than what Jatin bhai said. That's not a problem with construction disputes. That's a problem with arbitration in general. And in my own mind, it's I have a little bit of a more philosophical view on that. Is the Indian bar and the Indian judiciary divided on the issue of arbitration? Is it a territorial issue that you have actually in the bar itself people who say, okay, what if arbitration increases too much? On the bench, in various courts, the judges are divided that whether arbitration we should only be there as passing decrees or putting stamps, or we should be applying our own mind into the legal issues. And then a number of interestingly or ironically, a number of lawyers in India are interested in international arbitration than domestic arbitration. So it's the whole paraphernalia which needs to move in terms of thought process before you go to government or before you go to people like Mr. Ramachandran, who are not lawyers but are going to help it. First, the legal community has to be clear and send a message to the government that this is what we want. So there's utter confusion right now. Now, coming to what can be done, I think the first and the foremost thing is that what can Indian courts get into as far as arbitral award is concerned. The law has been clear. It has been repeated by Supreme Court. Only questions of public policy. Now, this public policy, you have stretched it so much that you start interfering right from Section 9, Section 8, these sections have become household names. Award is coming, okay, file this. Waiting for 1 year. I have cases in India where Section 11, which is appointment of arbitrator, are pending for close to a year. And it's a 15-minute job. The contract is very clear. Our position is very clear. So it's basically a mindset thing that the whole legal community will have to move. And the quick legal fix is to define what courts can get into when the award is there. And then all of us have to move through. I think there's limited time left and others should speak. But I think that's one of the things. As far as 75% is concerned, it's great. Legally, practically, Jatin bhai mentioned, it's a problem. Instead of paying to the government, you end up paying to the bank. So there's no advantage. So the practical aspect and the government aspect and the judicial aspect has to marry. Is this like the government can say, oh, we made 75%, now go and sort it out with the banks. Now banks have to figure it out. You go to courts, court says you already have a law, you already have the money, go and figure out with the banks. So it has to be a complete circle which will have to happen. I think in that list of 21 Ministry of Finance probably needs to be added to.
That's actually a very good point, sir.
So Pranay, I want to add here one small
of course,
point.
sir.
Sorry.
Of course. No, not at all, sir. Please go ahead.
One irony in the whole arbitration process. Suppose the arbitrators are ex-CJI and other two Supreme Court judges. The award is passed. Thereafter, as per section 34, it goes to the district court or commercial court for challenge. So it's a very awkward situation that the highest judge of the country, that is ex-CJI also, and the combination of Supreme Court judges have passed an award or are given an award that goes to the district court, district judge, with due respect to district judge. They are now analyzing and examining whether the award is passed properly or not. That's very ridiculous, according to me. And I'm still of a thinking mode every time whether this type of thing is happening in other countries or not. I don't know. But this has to be changed over a period of time.
I think that's a great question to put to Mr. Morkin. Mr. Morkin, it's clear that disputes have become commonplace in the construction and arbitration market in India. And a lot of issues that you would have heard right now, the panel discuss, relate to India being the seat of the arbitration. We are increasingly seeing Indian parties opt for establishments such as the SEAC, with the most number of parties being Indian, most number of foreign users being Indian. More recently, the Indian Supreme Court has allowed 2 Indian parties to also choose a foreign seat of arbitration. Given these developments, could you highlight how the possibility of Indian parties moving their arbitral disputes to foreign seats can help in the dispute management, especially of construction disputes?
Yeah, I mean, I think just before I go into that, Pranay, just picking up on a few points that have been raised by Mr. Jalmwala and Mr. Gupta. I mean, I think by the time you get into a dispute, it's in both parties' interest, or everyone's party's interest, for that to be resolved as quickly as possible. And one thing we see increasingly, and it was an issue in the UK market as well, and my practice is disputes, but I do quite a lot of assistance to my transactional colleagues when they're putting in contracts, is the idea to keep open as many avenues as possible at the time of contract to resolve this dispute. So having these multi-tiered dispute resolution clauses to give you options to go to senior management to get them resolved, expert determination, dispute adjudication board, and then ultimately end up in an arbitration. And it sounds very attractive at the point of contracting because you think at each layer, we're going to get this resolved, we can do it in a way that's cheap. But what inevitably happens is where you're not required to do it, but where you're contractually required to do it, you have to go through these processes. You spend significant time and money going through these processes, and inevitably the party that loses is going to take it to the next stage. So you're prolonging the whole resolution of a dispute, where in particularly the Indian market, you then have further delays in respect of enforcement through any challenges in the Indian courts. So I think in terms of best practice and as a way forward, I think considering from the very outset where you want to be and the quickest way to resolve a dispute, and whether you need, and to the extent you can, contract out of them, and I appreciate in certain jurisdictions there are requirements to go through adjudication steps and you can't do that, but whether you need all these different layers or you just go straight to arbitration, be that seated domestically or internationally. I mean, in terms of, what you can learn from foreign seated arbitrations, I'm not sure that there is, institutional arbitrations, SEAC, LCIA, the ICC, they're all incredibly experienced at administering arbitrations and ensuring that the process is conducted efficiently. But one of the benefits of arbitration is procedural flexibility and giving the parties the ability to create a procedure that enables the dispute to be resolved quickly. And actually, what we see in the majority of the arbitrations we do is that the institution itself becomes largely redundant. Their role is to appoint the arbitrators, and often in a large construction dispute, it's a 3-member tribunal. each party will opt for their own arbitrator. The third will be appointed by the institution. And then really they play a role of just facilitating the process, seeking payments. But if it's a properly conducted arbitration, it's the tribunal, sometimes with a tribunal secretary, together with the parties who facilitate the process and ensure it is conducted in the most efficient way possible. And that can happen regardless of whether an arbitration is conducted in India or it's conducted overseas. So what I think the benefits of an international seat can give you is exposure to counsel who are more familiar with the process and are experienced in helping parties to resolve disputes quickly. One of the biggest issues we face, I think the market is moving, is unnecessary procedural challenges along the way, which just delay things. And I think if you get experienced counsel now on arbitrations, there is just a desire to get things resolved more quickly and to get through the various hurdles of resolving disputes. Having foreign seated arbitrations can sometimes give you access to a greater pool of arbitrators, more experienced. You can select anybody as your arbitrator if they're willing to take the appointment. But if it's a third arbitrator to be appointed by an institution, they will look in their books as to who they have on the record, and often some of the most prominent arbitrators, particularly in the construction industry, will be affiliated towards the more reputable institutions at the moment. Now, hopefully that will change over time, but the ICC, the SEAC, the LCA have a great pool of arbitrators to do. I think then best practice really is then more on the parties in terms of how they conduct themselves during the arbitration with their counsel. So once you've got your arbitrator, be strategic as to who you appoint. Don't just go for a big name. Go for somebody who is going to help ultimately the resolution of the dispute. So if it's a very technical dispute, having someone on the tribunal who will understand the issues may help educate the other tribunal members and enable them to get to grips with technical issues more quickly and issue decisions along the way in disclosure or provisional measures more quickly. The other kind of best practice is and Mr. Gupta touched on this, is simply record keeping along the way, and then ensuring at the outset of your dispute that you collate those documents together and you give them to your counsel from the very outset, so that your counsel have a clear understanding of all the issues in play. And similarly, you give them access to your project management team so that they can then sit down with those people directly who are at the very forefront of those disputes to go through what can be very complex and detailed factual issues. But getting that head start from the very outset and making sure those people are available from the very outset can be really key to resolving a dispute efficiently. And I think that is obviously in everybody's interests. The final point in terms of best practice is the use of experts. It's very common in large-scale construction projects to require, in arbitrations, to require experts, particularly on issues such as delay, prolongation, and quantum, and sometimes also project management. And there is a real importance to have experts who are reputable in the field, who will help you and the tribunal to distill the key issues and enable you to present your case in a clear and concise manner. And I think particularly in this industry, worldwide, there are many experts who offer these services, but I'd say that there isn't a huge number who are, particularly well regarded. I mean, and that's that there are many that are very well regarded, but there are some who are better than others. And getting them, appointed quickly and ensuring they aren't conflicted can be a very, very helpful way at presenting ensuring you can present your case in the most effective manner. And one thing we've seen increasingly through the help we've been providing clients on project management, so before you get to a dispute, is actually engaging experts more quickly as well. If there are issues of quantum, prolongation or delay in play, and you're getting contractor claims claiming extension of time for 100 days or something on account of COVID, or design change, or whatever it may be. Don't wait until a formal arbitration before getting an expert to critically analyse that, to map the critical path, to do some form of schedule analysis. Start early, get your expert appointed, someone on your side. Doesn't need to be the full, extensive analysis that might be in an arbitration, but get them to work with you during that interim phase of, managing your dispute, managing your contractor, because it will enable you to put a much more robust defence into your contractor, and it will also set you up very well when it comes to a formal arbitration, because you have someone appointed, who's not conflicted, who's very much aware of the background to your dispute, which will enable you to put your evidence in much more quickly. Those would be my thoughts.
Thank you very much, Mr. Morkin. Mr. Gupta, Mr. Jalunwala, I know that you had some additional comments that you wanted to make. Could I briefly ask you whether there's anything more that you would like to add just before we move towards the last part of this discussion?
Nitin, you want to go first?
Yeah. Mr. Gupta, you please go ahead.
No, I think for me, the arbitration versus judiciary, the issue which you brought up is very emotive,
Yeah.
So I can go on and on that point. And I think I agree with Sunil on the point that preparation is extremely important. But the cost becomes an issue when you look at these things. And Indian contracts having been drawn from the projects contract in US also provides, because what India follows as projects contract are primarily from the time of Enron, which basically set down the whole tone in India from 90s. So amicable solution and all are available, but as I said earlier, that once it goes that path, it's a sliding scale. It just ends up in arbitration, because on the other side is a government officer with a lot of accountability, and you cannot blame that, but that's how the system is. So there probably could be an accountability build that on an individual level, that how many cases an individual officer refers to arbitration, how many he wins, how many he loses, and in the department, so that people have more accountability when they just pass on the baton to the lawyers without applying the discretion. I think that's what I will say. Thanks, Pranay.
Yes, Mr. Jalunwala.
Yeah, I just wanted to add here about the preparation of the arbitration, what Mr. Sunil and Mr. Gupta rightly said. And Mr. Sunil has said that we must have keep the records of the past correspondence and other things. One of the important points in arbitration is at the time of cross-examination and witnesses, we have to be fully prepared. And when our colleague has to be cross-examined, we shall be prepared with all the types of questions and all questions which are likely to be asked to him, and shall be prepared to him, asking question to him, preparing the video for that. And wherever he has made some mistakes, we should bring to his notice that this way he should reply. And similarly, when we have to cross-examine the other side, we should have prepared the exclusive questions and be prepared then how can we corner the other side by putting various questions. That preparation is also very important.
Thank you very much, sir. And I think just to conclude our discussion, which has been fascinating and has run over time, because I just think it has been that gripping and important. My last part of my question goes to Mr. M.K. Sunil. Sir, we began with the issue of how Gatishatki transforms itself from a dashboard to a reality of 100 lakh crores in the infrastructure and construction sector. We've heard extensively from our experts on the panel, including yourself, on how concurrently disputes can be managed. What, in your view, is key for all stakeholders to engage in for that reality to take place, where that digital platform actually converts to tangible projects? I'm sorry, sir, I think you're on mute.
I was saying I'm not a lawyer, I'm an architect by training. So I'm going to take it from the point that, when BIM was implemented in Singapore, I was party to it. I worked with them as part of Autodesk team in terms of doing POCs and getting that implemented. The good thing about that was it was a government initiative. It was top down, and there was a complete full circle accountability in a way. So they made available some funds for the industry to acquire the technology. So everybody who were going to start using BIM, they didn't have technology, so they could apply for the government funding and get this technology. Then there was this training that was actually taken up by the industry as well as building construction authority. So training was taken care of. Then of course, the government itself made it mandatory that all the projects, if you need construction approval, you need to submit it in BIM process, right? And then of course, so that was a closed loop kind of thing. Of course, people will ask, where is the money going to come for funding? You know, in India is such a large country and all of that. I firmly believe, and there are a lot of research that has been done around use of technology in construction in various countries. There is a clear understanding we could actually be 20 to 25% savings if you start using technologies like BIM and collaborative portals, technologies to host the project as well as share the project and record the project information. So as part of the Gatishatki, or what our Prime Minister has said, 1.5 trillion going to be spent in infrastructure projects. A 20% saving would be close to about 0.3 trillion on the table. Just because if you mandate use of this technology, that would actually give you 20% saving. That 0.3 trillion is a good amount of money to do all this kind of stuff that I just mentioned, which was done much earlier than, of course, BIM wasn't in the play when Singapore mandated BIM or other countries, but they took the decision to invest, and that benefit is coming today. They are saying the construction has gone up by 30%, efficiency has gone up by 30%, and all of that. How did that happen? Just because they enable the industry. So I think government needs to take a step where technology is part and parcel of the whole gamut of the Gatishatki endeavor. And it cannot be said that, okay, I'm just going to tell the contractor or the team that this project need to be finished by 1st of January. That is not going to help, right? People are not going to go and use the technology that's needed in some way. Some may do it, some may not do it. But I think government needs to actually bring out a policy around technology, one, but look at it holistically as a closed loop approach. Maybe industries and the government needs to come together, think about how we could enable, right from having some funds and training and all this kind of things coming together to make our industry efficient. People has to actually come forward and invest in infrastructure project. Today, that's a big issue, right? Because of a lot of challenges out there. Nobody wants to invest in infrastructure project that easily. But public project, of course, you see on a daily basis, there are so many projects being launched. But on the government projects, the infrastructure project, all this thing that I just mentioned, as well as bringing technology on board, will actually drive transparency and accountability. That's going to help elevate the ROI as a productivity and the whole speeding up the initiative.
Thank you very much, sir. And I also have no doubt that that would also lead to efficient dispute management as well. Dr. Ramachandran, I'll give you the last word for this fascinating discussion. First, I hope we have been able to convince you that there is a degree of link between how disputes in the infrastructure sector are resolved, as well as the larger goal of having infrastructure development. But be that as it may, what in your view are the key limitations that we need to overcome, and what suggestions would you put forth for Gatishatki becoming a reality and going beyond the mere coordination of ministries in the government to actual implementation of large-scale infrastructure projects?
Two parts and two responses. To your first question, ideally, I would have liked a title like Disputes and Arbitration in the Context of Gatishatki. Probably you're covering that segment more proactively. That's one part of it. The other part is I still see the big picture. I mean, since I've seen it from different places, and it takes years for some changes to be brought about as far as government projects, their management decision making is concerned. So if you are successful in moving away from a ministry-based approach to an interministerial approach where things get sorted out, that would be a big success as far as implementation of these infrastructure projects are concerned. But I don't think it's going to be that easy. This would be a first step, and one has to have the environment to have this work in the scheme of things, because there are issues like audit and limitations of ministries, decision-making levels and things like that. So I hope the Prime Minister with his leadership also puts in position where decision-making across the ministries becomes faster, easier. I'm still not very clear whether environment clearance, environment impact assessment and things like that, some of the statutory requirements, whether those can be expedited, because that would require a certain way of doing things. So how that is to be handled, that would be something which one will have to see as implementation of this initiative progresses. There would be hurdles like that. Also, what would be relevant would be how actively the states see the central projects as something which is of relevance for them. Especially in our politically divided context, I'm not very sure whether some states would be very excited to facilitate this process, or they may see some projects as of interest to them, some projects may not be of that interest to them. And I won't be surprised if some of them create issues about land and things like that, rehabilitation of people concerned and things like that. So we have to see this work, but I think it's a big step as far as the urge to get out of silo approach is concerned. If it works, fine, then there will be one big step forward. Along with that, all these other issues which have been referred to, I think contractor-related issues, contract-related issues, arbitration issues, everything goes round and round in our scheme of things, because everyone has to have the mechanism of, a proper way of resolving the disputes. So that is why it takes time. So on the basis of experience, there is something better is possible. That's a subject of study which has to come out, and which could become a big input into this process of taking Gatishatki forward, I think. Thank you.
Thank you very much, sir. And I think that is a very appropriate note to conclude today's absolutely fascinating discussion. I think we've heard some key issues to address what Samir sir began this discussion with, and that is to make Gatishatki beyond a mere digital platform to a reality. And I think the efficient handling of disputes is a key issue that we've been able to address. So with that, I thank all the panelists for their time and of course for their views. And I'm very grateful for everyone for attending this. Thank you very much.
Thank you.
Thank you. Thanks to all.
I'd like to thank all our panelists for taking the time to meet with us today, sharing their expert insights. No doubt that the takeaways from the conversation today are going to prove instrumental in shaping both policy and practice. Thank you, everybody.